Thank you very much, Gaurav. I just want to check, first of all, that I can be heard okay. Yep, excellent. So just to say thank you to Gaurav, and also to say thank you to Koldo, both for being here to organise this and to respond to the book. And thank you to the Research Group of Social Rights for hosting us at the International Association of Constitutional Law. It really is an honour to have an opportunity to discuss this with all of you, to give you some of my thoughts on the book and to hear from others. And I welcome responses from everyone. I mean, in the times that we're in, obviously this book was published in the midst of COVID, so there was no such thing as a book launch or anything like this. So this opportunity is just lovely for me to have a chance to actually reach out to scholars in the field to share with you the research and sort of the thinking behind it, and where I see the research in the book going next, what my sort of next plans are in terms of the research journey. So thank you, like I say, it's a real honour. And in terms of the genesis of the book, which I thought I'd first just give you an idea of why I wrote this particular book, what inspired it, so the sort of thinking behind it before the research began. So it really goes back to when I was still at school. And in 1998, I was 14 and I did a placement in a law firm in Glasgow, just in near my local school. And while I was working there, obviously this was the era of the Human Rights Act was coming out. It's such great promise. Scotland Act was also being passed. So in the next couple of years following this placement, we'd have all sorts of different new human rights that could be relied on in Scotland and in the UK. And whilst working in that firm, I think it was the first time that I realised the systemic issues that people face in relation to economic and social rights violations as part of everyday life, in terms of housing, health, education, mental health, the issues that children were facing in relation to access to schools, just the issues around systemic poverty. And at that age, I thought perhaps the Human Rights Act would provide a response to try and help some of those issues. And of course, as it played out, I mean, there's huge advancements made in relation to human rights under the ECHR Incorporation process, both under the devolved settlement and in relation to the Human Rights Act. However, it did not solve these economic and social rights issues, and I did not have the language or knowledge at the time to know that there was a separate human rights framework which was basically missing from our constitutional framing. So that was really the genesis of where this sort of first idea came of sort of systemic unfairness, injustice, social injustice in relation to economic and social rights. At a much later stage, when I was at university, I did work on Northern Ireland and the peace process in Northern Ireland, and I looked at whether or not there should be a truth commission in Northern Ireland post-conflict, similar to that in South Africa post-apartheid. And as part of that research, I realised actually economic injustice was a huge problem to securing long-term stable peace. And again, this idea of the economic and social rights violations just seemed to be missing from the discourse. And so as part of that process, I then undertook a PhD, which furthered the research in economic and social rights as a response to the gaps that emerged in transitional justice. And I did a PhD on economic, social and rights, economic, social, cultural rights justiciability mechanisms for a conflicted democracy, with a specific focus in Northern Ireland. And when undertaking this research, whilst it became really apparent that economic and social rights were often absent from transitional justice discourse and practice, the same violations occurred in other parts of the UK that weren't emerging from conflict. So the issues that were faced by people in Belfast were similar to those faced in people in Glasgow or Dublin, or in Leith in Edinburgh, or in Wales, or in other parts of London, Manchester, Liverpool. And so economic, social and cultural rights violations, it became clear to me at this stage, were simply missing from our legal frameworks, missing from our discourse. And so the book was a response in a great sense, a really strong inspiration was when trying to talk about this gap, this accountability gap. International human rights law says we have economic, social and cultural rights, they're indivisible from civil and political rights. But when this discussion came up in the legal community, in constitutional discourse in the UK, it was just rejected outright. There was no discussion to be had because the rights were aspirational, they were political, they were resource intensive, they faced issues around polycentricity, they would be a threat to democratic legitimacy and accountability. And so there was a frustration there that actually, if you just looked beyond the UK framework and looked at constitutional practice elsewhere, economic and social rights featured prominently as part of constitutional reform, and there was already decades of work being undertaken to try and address this accountability gap in other regions. And so the book really was a response in terms of trying to address two different narratives. And I mentioned this at the start of the book. In a sense, the first narrative is international comparative law had moved on for quite some time from the idea that economic, social and cultural rights were somehow of a lesser status. And there were huge strides being made in trying to address how to ensure their legalisation in a legitimate way through processes such as in South Africa and some of the constitutional changes emerging in Europe and also South America. Whereas the UK discourse was stuck in a sort of historical legal fiction that economic, social and cultural rights were somehow of a lesser status, and sometimes language would be used such as second generation rights or third generation rights. And when you look at the literature in relation to that, this is based on essentially a false dichotomy. It's not how the international framework was originally envisaged. It's since been corrected through various different reconfigurations of what economic, social and cultural rights mean in international law through decades of work. And so the UK was very much behind in that discourse. So the book tries to address that. And the chapters are set out in such a way as to almost frame it in a jurisdictional hierarchy. So the first chapter is about setting out the theoretical framework. So for me, the really important aspect of, again, responding to this narrative of social rights being lesser rights was to, well, let's look at the critiques, let's examine them, and let's see whether or not there are responses to those critiques which could help address some of the concerns around democratic legitimacy and so on. So as a caveat, the book was written from the assumption, based on moral and philosophical considerations, that economic and social rights are a good thing for society and they would be a good thing for the UK. And it's about trying to ensure some form of democratically legitimate way of making them enforceable and ensuring accountability for violations. So that was based on sort of philosophical and theoretical considerations around autonomy, citizenship, participation in society, and there's a long history of different theoretical strands which support that, including from a sociological perspective as well as from constitutional theory, and deliberative democracy theory played a really strong part, where drawing on the work of the likes of Habermas, Rawls and King, who wrote a great deal about the different sort of moral and philosophical stances, was to say that, you know, in order to incorporate economic and social rights in a legitimate way, it should ideally be through a multi-institutional approach. So rather than just say the judiciary is responsible or the government is responsible, it should be an approach which incorporates and embeds the rights in the work of Parliament, in the work of the executive and administrative sphere, and in the work of the judiciary, ideally under a constitutional framework which is cohesive and coherent, so that decision-making processes can be properly scrutinised and decision makers can be held to account. Deliberative democracy also played a really important role from my perspective in terms of looking at the theoretical positions, because again, that narrative that basically rejected the justiciability of economic and social rights from the outset was based on this idea that those types of rights should be for a political forum and not for a judicial. But my thinking was, well, if you give people the option, say, for example, citizens choose to constitutionalise economic and social rights, how then does law respond to that? because you could go through a political process where there's impetus to constitutionalise economic and social rights. So we need to then look at the options of how to do that legitimately, rather than get stuck in this sort of politicisation of the rights as aspirational. If citizens actually chose in a legal framework to constitutionalise them, how would that play out in nature? And so this idea of the multi-institutional approach was foundational to the work. And whilst it is a caveat that the judiciary and adjudication should always be a last resort, it requires to be there in order to ensure there's a framework where there's an ultimate accountability mechanism if all other institutional mechanisms fail. So that caveat is, of course, it's preferential if rights violations are addressed much earlier in the process, either through parliamentary processes, through the government's decision-making processes, through the administrative sphere, through, for example, all the other different types of complaint mechanisms that you can get, which are non-judicial, and ultimately the judiciary there as a means of last resort. And finally, that the sort of final sort of concept upon which this was based is that ultimately there should be an effective remedy for a violation. So in order for that system to operate successfully, there needs to be an accountability mechanism, and that accountability mechanism needs to be able to lead to an outcome which is effective in order to address the violation. So that was the theoretical foundation on which the book was based. And really then the chapters sort of take the theoretical foundations, they examine the critiques of social rights adjudication and then respond with principles which are derived from deliberative democracy to address the critiques. So whilst the critiques are really important and they have to be borne in mind when looking at legalisation or constitutionalisation or incorporation of economic and social rights, they are not insurmountable critiques. And that was the really important aspect of addressing this narrative of outright rejection of the justiciability of economic and social rights. And as part of that research, of course, when I looked at the UK specifically and on a comparative basis, economic and social rights are already adjudicated on a daily basis. They feature as part of case law in each part of the UK's jurisdictions. But they tend to be under the aegis of something else. So there is actually a history of economic and social rights adjudication. It's just that it's not recognised as such from the outset. So the critiques were based around the anti-democratic critique that social rights should be adjudicated in another forum, not within a judicial one. The indeterminacy critique that rights are too vague, that the international framework doesn't give enough meaning and content to rights. And there is therefore a gap in terms of what the substantive nature of rights mean. The capacity critique, that courts aren't well placed, they do not have the capacity to respond to these types of issues, nor the expertise or the institutional mechanisms. And finally, the pro-hegemonic critique. And I separated these out into two waves. So the first wave was the first three critiques, which is basically before you even consider a legalisation or incorporation of rights, these critiques tend to be versed, and you see them come up in sort of parliamentary processes and commissions and investigations into whether or not to give legal status to the rights, and they are sort of the outright rejection. But there are responses to those critiques, including, for example, the court being an accountability mechanism that should not abdicate its role, that it's in a multi-institutional framework and that meaning and content is given to rights by the different actors in that framework, that there are means of responding to issues around capacity and so on by using principles around participation, deliberation, and facilitating the rights holders themselves in responses to what rights mean, and the expertise required to respond to sort of some of the vagueness around rights. And of course, what's really important in relation to the pro-hegemonic critique, which is essentially that when you actually introduce rights into a framework, there is a tendency under economic and social rights that there could be a tendency towards affording more rights to those better off in society at the expense of those who are worse off. So Brazil is often used as an example of that, where the right to adequate health, for example, was used by those who had easier access to the legal system to improve their access to rights, much to the expense of those who were not able to access the legal system, didn't have the means to do so. So that critique is one of the key ones, because actually when you look at social rights, economic and social rights adjudication, one of the key components of it is that it really has to be designed in a way that facilitates collective responses to systemic issues. And one of the big issues around violations of economic and social rights is that they tend to be systemic in nature, that it's not just one person that faces problems around poor housing, not being able to access adequate healthcare, not being able to access education, employment rights issues, minimum wage issues. They tend to be systemic in nature, and so ideally social rights adjudication requires to be counter-majoritarian in its response. So the principles that address the critiques are based on what I would term as the adjudication journey. So it helps to try and understand what cases get to court and what cases do not, because ultimately, if you do not overcome the first hurdle of being able to access a legal process to try and ensure an effective remedy, then you're essentially excluded from the system. So it's actually very much based around this concept of access to justice is being understood as not just access to the legal system, but ultimately access to an effective remedy as an outcome of that process. So in a sense, reconceptualises access to justice as going beyond the sort of first hurdle of access. So accessibility, participation, deliberation, fairness, the counter-majoritarian principle and the remedial principle are the principles which basically operate throughout the book. They are a heuristic device in a sense that they are based on trying to highlight flexible principles in terms of how a court might respond to issues. So first of all, there needs to be access through advice, advocacy, legal aid, make sure there's non-prohibitive costs, that standing is facilitated, that people have access to advocacy, that public interest litigation can be raised, and so on. In terms of participation, it's sort of framed around the idea that not only do rights holders have the right to participate in proceedings which affect them, but ultimately should also be able to participate in the outcome of those proceedings around what remedies they deem to be effective. As well as facilitating third-party interventions, ensuring that you can have collective litigation, ensuring that, for example, a human rights institution can take a case on behalf of a group that are marginalised. The principle of fairness is one of the key ones around which the book really delves into the idea of the intensity of review that's undertaken by the judiciary, as well as the types of remedies that are offered. And this is really the crux on which a lot of social rights adjudication is still contested, because there are two ways of looking at adjudication in terms of should the adjudicator, the judge, be looking at the fairness of the procedure around the decision-making process and whether or not it was reasonable, or should they also assess whether or not the outcome of that decision-making process was fair? And this is where the difficulty arises. You can see, for example, on one hand, the right to reasonable policy, which is evident in a lot of the South African adjudication, compared to, for example, adjudication emanating from the likes of Colombia, or the Hartz IV case that I mentioned in relation to Germany, where there is a focus on not only fair procedure, but also whether or not the actual decision itself violates a right. And I propose different ways of addressing this. Social minimum human dignity is one threshold, which is basically minimum core obligation. And the second is looking at a peremptory norm that is actually in a statute itself. So for example, if the legislature passes a statute to say everyone should have access to vaccination, for example, then that becomes a substantive standard which an adjudicator can enforce, rather than looking just around the policy or the reasonableness of the steps taken. So there's a lot in there in that principle. Of course, deliberation is about deliberation vertically, horizontally, between institutions, between different jurisdictions, how to assess human rights adjudication in terms of the deliberative nature between, including stakeholders that are impacted. The fairness principle I've mentioned already. The counter-majoritarian I've spoken about to some extent, and that is really about addressing the pro-hegemonic critique. And finally, the remedial principle, this idea that ultimately there has to be an effective remedy, and remedies are much more complex than would first appear. And with economic and social rights adjudication, I think probably the future of a lot of the work in terms of scholarship will be looking at complex remedial responses, and using, for example, Tushnet's approach to weak v strong, and then Garavito Franco's approach to moderate remedies, and trying to scope out responses, remedial responses, which are complex in nature, appropriate, prompt, and effective. And what does that actually mean in practice? What different remedial responses are needed? How much should there be supervisory jurisdiction, and so on? So the framework is essentially throughout the book. The book itself then moves on to what I call the jurisdictional hierarchy, and that's why I mentioned the focus here very much was on the UK, but trying to draw an international law as well as the devolved lens. So the subnational lens is particularly important in the UK context, because actually the devolved regions have gone so much further in terms of looking at international human rights law as a substantive component of the rule of law and attempts to incorporate. And so the UK is put in this difficult position of being in a regressive sort of approach, looking at things like repeal or amending the Human Rights Act, whilst the devolved trajectories are looking about progression and further incorporating international human rights law beyond civil and political rights. So the jurisdictional hierarchy is based on looking initially at the international framework, where I set out the requirements for an effective remedy as essentially part of, or a subcomponent of the obligation to progressively realise rights, drawing on General Comment 9, drawing on the Maastricht Guidelines in 1997, the 2006 UN Basic Principles and Guidelines on Reparations and Remedy, but also the legal framework, Article 8 UDHR, Article 13 of the European Convention of Human Rights, Article 47 of the EU Charter of Fundamental Rights. The right to effective remedy is becoming more embedded in our understanding of access to justice and as a right in and of itself. And this is apparent in the UK context in terms of common law application through, for example, the Unison case, which deemed prohibitive costs were a violation of the right to access justice. So the international framework is the right to an effective remedy, and also addressing the fact that the sort of historical bifurcation of rights was based on a misconception and certainly a legal misunderstanding of the status of economic and social rights. I then look at the regional context, which was probably one of the most frustrating chapters to write, because every time I felt like I'd finished it, there would be a new change to Brexit, a new agreement in place, a new protocol. But the regional framework looks at basically the European Union and the Council of Europe as sort of two pillars of the UK constitution, both of which were under threat. Essentially, while they were not the most effective way of enforcing economic and social rights, they were important mechanisms through which people could access a route to remedy for a violation, and both have been subject to well, essentially Brexit, removing the UK from, for example, the legal status of the EU Charter of Fundamental Rights, and the Human Rights Act, subject to amendment under the current review into the statute, where there could be changes and regression on rights protection in relation to civil and political rights. The book then takes on the sort of constitutional resistance to human rights in general in a UK framework, and you do see similar arguments elsewhere when, for example, a country is first considering or re-examining the status of human rights. a lot of this similar sort of constitutional resistance can appear, particularly in neoliberal models of democracy, where there is problems around distributive justice. And the UK Constitution's rejection is essentially based on the idea that parliamentary supremacy should prevail over any sort of judicial accountability mechanism for the provision of rights. And there's a really strong resistance to any form of constitutionalisation of rights. Meanwhile, however, at the devolved level, you essentially see legal constitutionalism at play, because there is a constitution through the devolved statute. It would be incompatible, for example, with devolution for the Scottish Parliament to exercise in any way, undertake to pass legislation which contravened the ECHR. It would be deemed ultra vires from the outset. It wouldn't be possible for the Parliament to do that. So there's a legal form of constitutionalism, a framework model where all actors, Parliament, executive and judiciary, all have to comply with the same substantive standards. And these two different types of constitutional models are both at play in the UK context, and there is a flux between them, which means there is no real coherent and cohesive constitutional framework for rights. And I go through some of the comparative models using, for example, Finland and the parliamentary focus on legislation being the place where remedies are initially sought for violations of social rights, that it's the committee within the legislature plays that role of a strong parliamentary model, and then compare that with a model which is more about judicial responses such as South Africa or Colombia, and look at the different ways through which you can basically see that on the spectrum. And the UK doesn't really fit comfortably on either of those models, because there is no sort of framework in which either the Parliament, the executive or the judiciary is bound to comply with economic and social rights. The book then moves on to the existing justiciability mechanisms for social rights. These are key mechanisms through which the outright rejection of economic and social rights as justiciable rights can be repudiated, because it already happens on a day-to-day basis. You see the adjudication of rights through the statutory framework, through equality law, through a dynamic interpretation of civil and political rights, and through the common law interpretation of international human rights law. And there are examples throughout those chapters of how that works in practice. For example, the ZH Tanzania case, which essentially incorporated the UNCRC provisions in relation to the best interest of the child when interpreting Article 8 of the ECHR, and Lady Hale was very much at the forefront of that type of approach. And there's a lineage of those cases now in which international human rights law is an important interpretive source when looking at interpretation of convention rights. So the justiciability mechanisms help set out what currently happens both in the UK and elsewhere. You tend typically to see the same types of mechanisms adopted. And then finally, the book proposes two further mechanisms. The next one, which would be a natural follow-on from the Human Rights Act, would be an international complaints mechanisms, such as that under the European Social Charter or under optional protocol to IACL, where you could have adjudication and a remedial response to ECR violations at a supranational level. And finally, the model which is proposed as the most democratically sound, and I've spoke about this already at great length in terms of the first chapter, is the constitutional model, where you see a multi-institutional incorporation of rights, either through an act which incorporates treaties directly, or which has a sort of homegrown domestic internalisation of international human rights law. So that's the justiciability mechanisms, and the book then finishes, and I'll finish on this point because I have spoken at some length, is the devolved lens, which, as I say, has been much more progressive in its trajectory around human rights protections, and really, in a sense, does propel the UK into a position where it's faced with addressing its own accountability gap. There are threats, in a sense, to state unity by not looking at what's happening at the devolved level through, for example, the Social Security Act in Scotland, the UNCRC Incorporation Bill, which is currently passing through the Scottish Parliament and the First Minister's Advisory Group and the National Task Force on Human Rights Leadership, which is seeking to incorporate economic, social, cultural and environmental rights. In Wales, you have a number of measures and acts which directly seek to integrate international human rights law into Welsh devolved law. The most recent is in relation to the right to adequate housing. And then in Northern Ireland, the Ad Hoc Committee on a Bill of Rights is now re-examining the possibility of a Bill of Rights for Northern Ireland, which incorporates rights beyond the ECHR. So you have the devolved trajectories almost acting as an important lens and mirror to the UK, which has rejected the legal possibility of legalising economic and social rights, whilst at the devolved level it's already underway. And so I'll finish on the point that actually, in a sense, the devolved frameworks will act as an important mechanism through which to scrutinise the continuing resistance at a UK level to have a more comprehensive system which internalises international human rights law in relation to economic and social rights. Thank you.
Thanks a lot, Katie, for that excellent overview. It couldn't have been easy to provide this in such a short period of time. It's much of your life's work. So thank you. Thanks a lot for that. We'll now turn to Koldo for some comments. Koldo, you're up.
Thank you. Thanks, Gaurav. Thank you to the International Association of Constitutional Law for organizing this. And thanks, Katie, for giving me the chance to join you in presenting this book. I told you right before we came in off air, as they say, and on social media the other day, that this was one of my favorite books of last year. And 2020 is not a year that we're going to forget easily. And I mean, it was one of my favorite books in general, and certainly on economic, social, and cultural rights. I think lately there have been very interesting books on these rights that we are so passionate about. And I will just mention two other books on the topic for those of you interested that you may also want to read, apart from this one, which is exceptional. I really enjoyed, published also in 2020, the book edited by Jackie Dugard and Bruce Porter, Research Handbook on Economic, Social, and Cultural Rights as Human Rights by Edward Elgar, and the book edited by Catherine Young, this one maybe in particular, in 2019, The Future of Economic and Social Rights by Cambridge. So these two books are great, but these are collective volumes, and Katie took this challenge on her own and gave us this exceptional book that I'm so pleased I have read. I think it's a very necessary contribution, obviously for the UK context, but also internationally. I think it enlightens a lot about what we're going through in the UK context, but it gives us a lot to learn for other countries that are going through constitutional moments. I'm thinking in particular of Chile. Chile is a country I am doing some work on at the moment, and there's growing interest in the current constitutional process in the country to embed social rights better, as you know, Katie, to embed social rights better in a new constitution for the country that will replace the one adopted under Pinochet's era, which basically ignores social rights. And I think it will be interesting to see what happens in Chile. Chile being the lab of neoliberalism, it will be interesting to see how far this country goes in constitutionalizing and enhancing the status of social rights. But coming back to the UK again, I think this book tells us a lot that is useful for the UK context, because a lot of things have changed in the last 5 to 10 years in the UK. And you mentioned, and you devote the whole chapter 6 of your book to devolution and social rights, and how far the devolved administrations in Wales, in Scotland, and less so perhaps in Northern Ireland, despite the Belfast Agreement, have advanced in the progressive recognition of socioeconomic rights. Sometimes we focus too much, particularly those of us living in England, focus too much in what's going on in Westminster, as important as it is, and we assume that it must be the same in the other 3 nations when it isn't. And this is one area where it clearly isn't. There is a lot of progress being done in recognizing social rights in the other 3 nations. But also at the level of advocacy, there is a lot of work being done by lawyers in court trying to push the limits of the Human Rights Act to try to get the most out of it to protect social rights indirectly. And I know there are some people in the audience that have a lot of experience doing that. And also they are very much aware of how far the Human Rights Act can really go in relation, for instance, to welfare reform. There are certain things that can be achieved in relation to social security, but surely there are a lot of limits that the recognition of the right to social security could potentially address. Something I really like of your book, Katie, is the focus you put on active participation, on the importance of listening to the people, to really know whether people are going to benefit from human rights and what they think of human rights. There is an assumption, isn't there, particularly maybe more so in England than in Scotland, that human rights are not a very local idea. They are not part of our identity. They're not part of our history. They are alien. They are European. They are international, but they are not British or they are not English. And I have the suspicion it's not so much the case in Scotland. I certainly, the case in England. I think it's true. Some people push that agenda in the English political context, but if you change the debate, if you encourage people who are often ignored by the political system, people who benefit a lot from enhancing the right to housing, the right to health, the right to education, the right to social security, if you encourage them to participate in the conversation, if you really are interested in their opinion on the matter, then you'll get a different opinion. A lot of people, my impression working in England is that a lot of people really value social rights, and it's not only what they value as rights to address their needs and what they may need in their life. It's also that social rights is actually very much part of the history of England and the UK. I mean, it's not true that they are alien idea. I mean, they are the social rights at the end of the day is social justice plus rule of law, and these two concepts are very much part of a lot of the history of this country. This country has a complex history, but these two concepts, rule of law and social justice, are certainly part of it. I would like to share with you basically 7 questions with you, which I will formulate very quickly. And I may have some others that I will leave it for later, but 7 questions for you. And I don't expect you, Katie, to address all 7 of them, but in case you want to answer any of them. And 5 of them are more general and 2 are more about the institutions of the UK. And I don't want to put you in trouble with the last 2, and I know this is being recorded, so I invite you to ignore the 6th and 7th question, but I will formulate the questions anyway. Okay, if you don't mind. Okay, let me start with the first one. You say in your, when you're concluding the book, page 267, that looking at comparative examples from South Africa, Colombia, Argentina, Finland, and Germany, countries that you cover extensively in chapter 5. In chapter 4, you say that it becomes clear that the UK could develop an approach to ESR adjudication that is cognizant of parliamentary supremacy, should it so wish. And I will ask you here, to what extent is this really, to what extent will this really be the case? I mean, considering how far does the limit of parliament supremacy, how strong is the limit of parliament supremacy, which is a defining principle of UK constitutional law? What's the limit that it imposes on how far we can go in recognizing, in giving power to judges not in the default administrations, but in Westminster? And is it a matter of fundamental principles of UK constitutional law, or is it something that could be addressed, for instance, if we had a different approach, such as, for instance, when you mention the right to effective remedy of Article 13 of the European Convention on Human Rights, which was mysteriously not part of the Human Rights Act? Is it a matter of political choice, such as we could imagine a Human Rights Act with Article 13? Or is it a matter of fundamental constitutional principles of the UK, that there is a limit of how far we can go in enhancing social rights, maybe unlike other countries that don't have this very particular feature of the UK legal system? I know this is maybe this is a UK specific question. I have another, I found very interesting, obviously, when you address the South African example and when you talk of the principle of reasonableness in South Africa. On page 65, you talk about the obligation to fulfill as being, I think you say, being potentially justiciable. And I wonder, are judges well equipped here? I mean, going to your answer to the critiques of social rights in chapter 1 of the book, are judges well equipped really to address with the obligation of fulfill? I mean, aren't they better? Don't they have better tools for protect and respect than fulfill? It's a question that I asked myself many times. And when I saw your point there on page 65, it came to my mind. Okay. Then another sort of controversy of human rights is obviously the issue of inequalities, and you go head on addressing Samuel Moyn's critique and many others, but many others as well. On page 10, your introduction, and you say that the international human rights framework offers a helpful framework for moving beyond social minimum thresholds and addressing in the context of addressing material inequalities. Can you tell us a little bit more about this? I know it. I mean, maybe judges on their own are not capable of addressing material inequalities. Maybe by having a broader conception of human rights, that includes the other principles of fairness and accessibility and participation. Maybe that more holistic view of social rights can help address material inequalities better. But can you address this critique that maybe we are focusing on tools by giving power to judges? We're focusing on tools that are very important, but that focus on the minimum level rather than the distribution of resources and inequalities between us. And as I said earlier, I really liked your focus on the principle of participation. There's a quote, page 149, you say the marginalization of particularly vulnerable groups essentially means that representative democracy does not represent everyone. I'm sure that we all agree that democracy is very important, even representative democracy is very important, but not everyone is equally capable of participating. Not everyone is being listened to the same way. But then when we look at examples out there in comparative law, such as the South African meaningful engagement principle, there has been a lot of questions about how far this principle has resulted in really actual meaningful engagement and participation of people affected by decisions. So what does you yourself say that on page 27, you say that participation and meaningful engagement in the adjudication process in South Africa has come under criticism for failing to give substance to rights. So how far can we really go with embracing active participation? How far can it really deliver the principle of active participation? Now, the fifth question, if I may, is a question that I asked myself when I was working with colleagues, as you know, in this project at Newcastle University. We were trying to put together this bill, and a very ambitious project, similar to other projects that you have. And one of the questions that we asked ourselves when we were trying to think about a bill on economic, social, and cultural rights in the UK was incorporation or recognition. Should we do something like the Human Rights Act? As in, should we refer to an international treaty that already exists? We don't make a change to it. We just accept it as it is with its pros and cons. And we say that there is some legal obligation to comply with it to some extent, or to a great extent, or just to due regard extent. Or should we come up with our own, or the British Bill of Social Rights, or the British Bill of Human Rights? And what are the pros and cons of these choices? And do you have thoughts on this? You cover this in a very, very helpful tables, page 190 and 194, I think it is. And you elaborate extensively, but you present the different options. Which one is yours, if I may? And now, finally, the tricky ones, the tricky two questions, and you feel free to ignore them if you want. The first one is, what is your opinion about how the Joint Committee of Human Rights is scrutinizing compliance with ISESCA in recent years? Do you think it's doing it okay? Do you think it's not doing it sufficiently? And what is your opinion about what's going to happen in the UK Supreme Court in the years to come? In how far are they going to go in having a progressive attitude, willing to expand the limits of current law to maybe enter into domains of social justice issues, now that Lord Kerr and Lady Hale are not there? What's going to happen in the UK Supreme Court? Thank you.
Thanks a lot, Koldo, for those very invigorating questions. They overlap with some of mine as well. So I'll invite Katie to respond to some, all, as you wish. Go ahead. Floor is yours, Katie.
Thank you, Koldo, for such a comprehensive review. And yeah, they're excellent questions, and some of them I don't think I necessarily have decided on a concrete answer. I think in relation to many of them, one of the things that it highlights is that really there's no panacea, there is no perfect way of doing this. There will always be challenges, there will always be specific constitutional contexts that need to be taken into account, whether it be the UK or Chile or Scotland or Northern Ireland. It's you know, there's different considerations, and I think it's about trying to have a participative and informed process to bring people along in terms of what the options are. And you know, this idea again of deliberation and deliberative discourse and deliberative democracy is about really giving people genuine options on which to participate in an informed and inclusive way. And there's a big participation essentially in designing models for a specific context is actually probably the first place to start. I actually think a lot of the work that's gone on, for example, in the UK and England in the past sort of 5 to 10 years has really pushed the discourse that wasn't there before. For example, the work of Just Fair in terms of redefining the debate. But what you tend to see in places where there has been transformational constitutional change is that there has been a huge participative process around that. It's never perfect, but I think there's probably a lot more work to be done in the UK and especially in the English context to try and set out some of actually the genuine options for potential change. And that's why, again, it comes back to that thing that I found so frustrating all the time, that you never got past stage one of having a discussion because it was dismissed outright as aspirational and not legally possible. So I think even that kind of discourse early on is key to change. In terms of compatibility issue, your first question around parliamentary supremacy and effective remedy, again, it's a balance. I mean, I think the Finnish model is a really important one where you could see, and it relates to your question on the role of the Joint Committee of Human Rights. Ideally, in a multi-institutional framework, the Parliament would play a much more prominent role in scrutinising, self-regulating, so scrutinising itself, and actually the committee could play a key role in that in relation to compliance. You know, effective remedies don't necessarily have to happen, of course, in a court. They could happen early on in the parliamentary stage where something's corrected that would cause a violation of a right. They could happen in the administrative sphere or in other alternative mechanisms, and ultimately they could have an effective remedy could be in court. Around the actual, which the point I think you're getting to is it really legally constitutionally possible to hand over the right to the court to declare a piece of parliamentary legislation unconstitutional in a sense, or incompatible with economic and social rights? Well, there is a precedent. You know, the European Union Communities Act of 1972 essentially amounted to a constitutionalisation of EU law. Now, we know that that's obviously had huge problems in terms of the rhetoric around the supranational role of law in a domestic context, but there is an example where you have cases where the judges were able to declare legislation incompatible. The Factor Time case, obviously key. Benkar-Bush is another case where remedies were much stronger. So I think it is legally possible, but I think it's about whether or not the political and civil society impetus reaches that stage, which will be the challenge. But ultimately, yes, courts can play a role in giving an effective remedy, but sometimes an effective remedy will be potentially a deferential one, because it will be so complex in terms of polycentric issues that the court has to hand it back to the decision maker, but may continue to play a supervisory role or assess the reasonableness of the steps. It might not always necessarily result in an outcome which invalidates a law or compels the government or parliament to do something. You know, that's what complex remedies are about trying to get that appropriate balance, and it's something that's in the UNCRC bill in Scotland at the moment. There was a provision that courts should issue remedies which were just and appropriate, and based on evidence that is submitted around effectiveness of remedies, there's been an amendment put through that said that the courts must issue a remedy which is effective, just and appropriate, because just and appropriate to the court may mean hand it back to the decision maker, but if you include this idea of effectiveness, you're actually considering what it means to the person who's impacted. it relates then to your second question about reasonableness in South Africa. Yes, again, you know, this is really complex. It depends to what extent you want to go in that spectrum about outcome-oriented orders, which relates to, you know, that weak v strong review, the different kind of heuristic devices that Katie Young has written about, which are about the types of or intensity of review. And I think actually sometimes there has to be discretion and flexibility when the more serious the violation, which is really what you see in Colombia, if it's an unconstitutional set of affairs, if it violates minimum sort of dignity, social minimum, then the more responsive the court has to be to intervene. And you see this in the UK context. There was a case recently of a young woman who was an asylum seeker, didn't have access to housing, no recourse to public funds. She was pregnant, she had her child, she needed to access medical care. She hadn't been housed, she was in temporary accommodation, which was really dangerous. The window didn't close, she didn't have any heating, the child was at risk, she'd had surgery. And the court stepped in and said, this is simply unacceptable. The decision maker hasn't justified why they haven't found a more appropriate accommodation, and we're issuing an interim relief, which is an immediate order that she's put in a more appropriate house by 5 p.m. tonight. So you see this type of response. I mean, that is a really strong substantive response because the circumstances demanded it. Whereas in other circumstances, it may be more appropriate to take like the group room approach, which is about assessing the reasonableness of the policy and the strategy, because it's simply not possible to say everyone has to have access to this type of housing by 5 p.m. tonight, if that makes sense. I think in your question around Moyne, yes, I think that his critiques are really, really important. Essentially, you know, if you think about going down the process of trying to use international human rights law when it might be not fit for purpose from the outset, and international human rights law is not perfect, and actually many treaties try to address human rights violations in different ways. So the European Social Charter has freedom from poverty, for example, whereas in IACL you sort of see a fragmentation of poverty into food, housing, clothing and so on. So you have different approaches in different treaties. And I think really Moyne raises really important points about just the inequality is so vast that are we just starting from the wrong place and using the wrong vehicle to get there? But actually it doesn't take into the sort of the global experience of economic and social rights. It's much more Anglo and American centric, and also you know, I really like Paul O'Connell's work. He does something around sort of this idea of displacement theories. You don't necessarily have to say, well, international human rights law doesn't work. I think it's about exploring how it could work better, rather than simply sort of pushing it to the side and saying adjudication isn't appropriate. Really, when you're dealing with economic and social rights violations, like I say, there is no perfect answer. You have to exhaust every route to social justice, whether it be politics, whether it be public interest litigation, and the amazing work you spoke of in terms of the lawyers who actually try their best with the tools they have. Ideally, I would like to see their tools improved so that they can, you know, get better results for their clients to address sort of social injustice. In terms of the limits of participation, I completely agree. I think often that's conflated as a participation as the answer, and again it's not. It's just, and that's how it's framed in the book. It's one principle. It doesn't address substantive unfairness, including people in decisions that impact them, doesn't necessarily result in an effective remedy. And I think this is around, again, the process v substance debate. So participation and including people in, for example, remedial orders is a right to a process. You're giving them the right to participate, but you haven't guaranteed an outcome that will address the violation. And so you still have to have that second aspect, which is substantive fairness. And that is really difficult because, like you say, sometimes it isn't possible or appropriate to impose an obligation or to issue a court order which is about the right to fulfill, as you correctly defined it. So that's sort of more substantive, outcome orientated response. But again, it comes back to this idea that really ultimately remedies, wherever they are, will probably need to be complex, and when they're dealing with systemic issues, they need to be structural in their response rather than this, you know, individual one at a time sort of responses which are based on damages, which is what the UK framework is. It just doesn't respond well to systemic issues at the moment. In terms of what I would say I prefer strategically, I think you can have incorporation through a direct incorporation act like you have in Norway. I think you could have, or in other settings in constitutional frameworks, you could have a domestically framed bill, which is more like the Finnish sort of constitutional model, or you could have a mixture. The pros of a domestic internalisation of international norms, because ultimately there always needs to be more substance and content and help to define what rights mean. The international framework doesn't provide a full answer on that. A lot of it is about states giving meaning to rights themselves. So I think that a domestic framework, which is homegrown, can help bring people along in that process. But the danger is that it could end up in a dilution of international human rights norms. So for example, in Hungary, in the constitution, you see some examples of rights, but really they're saying only insofar as it's possible within the legislative framework. So you sort of have a restricted form of domestication. So yeah, I think you could have either or both. The South African approach is really good in terms of it's a domestic version, but there is a requirement where you must have regard to international law and you may have regard to comparative law. And I think that's a really key way of enabling, the interpretation of a domestic version of Economic and Social Rights Act or so on is basically an internalisation of international human rights law, whilst also still allowing sort of a domestic interpretation. On the role of the GCHR, I would prefer it was, enhanced in terms of scrutiny. I think that's something I would hope, to encourage. I used the example, I think, of the SG case it was, where there was concern over Welfare Reform Act. JCHR raised the issues. The Welfare Reform Act was skeletal in nature. The regulations that came later resulted in really serious human rights violations. And then eventually when it went to court, the court says, well, it's, these treaties aren't incorporated. So whilst we recognise there's a violation, we can't do anything about it. So the court and the Joint Committee on Human Rights both raised the flags. But ultimately, there was nothing either could do to provide a remedy, and that is where I would say, that it just does not go far enough as a constitutional model. The role of the Parliament and the court ideally should be enhanced, and the GCHR it really could take on a much stronger role, much more similar to the Equalities and Human Rights Committee in Scotland, that has sort of enhanced its role of scrutiny. And I do really like the Finnish approach to that. The Constitutional Law Committee does do a really good job of pre-legislative scrutiny for social rights, and again, not in a perfect way, but it does provide a good example of that. And in relation to the future of the Supreme Court, I always think, I don't make comments on or I don't critique the judges themselves in terms of how they respond. I think, in a positivist framework, the judges will apply the law. And actually in this multi-institutional framework or through incorporation of rights, you're not asking them to perform an unconstitutional role. They just need really clear instructions on what it is they're supposed to do. So for example, incorporation of economic social rights, whether that be sectoral through an Economic and Social Rights Act, or just a particular piece of legislation that says right to adequate housing is to be enforced in this way, they'll respond to the instructions that are given. Problems around that will relate to things like the test that they use, the intensity of the review, wetness, very reasonableness, and irrationality as a test just will not work. It won't operate in a way which facilitates reasonableness as it's understood in international human rights law, or in the example of South Africa, which is influenced the approach in the optional protocol to IACL to take reasonable steps. The irrationality test in the UK is far too high a burden, and this idea even of manifestly without reasonable foundation, which has been really successful in cases where you have like Pantellerisco, the Cox case, the O'Donnell case, cases where welfare reform have been, if algorithms in decision making which exclude people from welfare benefits have been considered to be unlawful because they are irrational, they are flawed from the outset, they are manifestly without reasonable foundation, and that is a reasonableness test that's really high. But for a wider sort of adjudication of economic and social rights, you need a much stronger version of reasonableness. And I think the changes that you'll see in the Scottish approach to incorporation will try and address some of those issues around intensity of review and being able to have complex remedial responses to violations, structural responses to systemic issues. Thank you. They were really great questions.
Thanks very much, Katie. Very comprehensive answers. Thank you.
Thanks, Katie and Koldo. I'm going to invite the audience members to, I'm not sure if you're able to raise your hands here. Are you able to do that?
I think not, but they can do this.
Okay. I have two questions, so I'm gonna use my position as the moderator and pose a couple of questions, and then whoever has a question can use a reaction, and then we can take them. So, and this question, both of these questions are to both of you. So I'm going to put on my hat as a doctoral candidate, and I'm going to ask you what you see are the limits of the kind of scholarship that you engage in. So I'm just wondering what it is that we've lost by being slightly siloed. And this, of course, is a sort of proclivity that lawyers have of generally working in silos. So we don't interact as much with the political science literature in quite the kind of ways that that is necessary, that is deserved. So what do you think that we've lost, especially in the realm of social rights, where there's such a rich literature on welfare states across the world? So do you think that, and how can we do that kind of scholarship better? And the second question is about how, Katie, especially how your approach to the book or the kind of questions that you raised has been changed by the pandemic. And I mean, it's the kind of issue that I think we've been skirting around a bit. So what I'm curious about is that what you seem to hint at is that there is a politics of devolution which works to strengthen the rights culture and political resistance to social rights in the devolved territories. And what do you think the effect of the pandemic will have on the political culture more broadly, and on social consciousness, and on rights consciousness more broadly? So these are my two short questions. And then if anybody else wants to raise questions, can you just, I mean, I guess you can use the reaction button. So do you want to take these first, and then we can, or do you want to collect them in a bunch? How do you want to do this?
I think if there's questions there, we'll take them and respond as a bunch, or we can just go ahead. I don't mind.
Okay, I just saw a reaction from Lisa. So do you want to, maybe you can take mine and Lisa's questions, and then we can go for a second round?
Sure.
Okay, thanks a lot.
Oh, hi, Katie. Thank you so much for this brilliant presentation. Very inspiring as always. I was just wondering, very quick question, whether you've received any critics since the publication of your books, and if so, what were they? Thank you.
Great. Koldo, will I go first and then hand over to you?
Yeah, sure. Thanks.
I think actually I really would need to think some more about what your question was around about what's missing. I mean, in terms of where I think gaps emerge and where more scholarship is needed in relation to the book, I think the principles that are proposed pouring deeper into what they mean, like participation, accessibility, deliberation, fairness. For me, one of the big ones that the hurdle that I couldn't get over was resolving this issue around review through process and review of substance and like participation not amounting to substantive rights enforcement, trying to balance reasonableness review, proportionality, and more outcome sort of oriented. I think that is a big area which requires much deeper scrutiny. I think also, just more broadly speaking, that you have essentially, already mentioned what one of the ongoing and important scholarship pursuits is, which is interdisciplinary research. The more, the better. It's so important, and it's so difficult, but so many people are trying to answer the same questions from completely different disciplinary perspectives, and actually much more work needs to be done to bring those perspectives together, not just political science, sociology, philosophy. I think trying to work across sectors in terms of, responding to the right to adequate health is not possible unless you have the legal perspective, the medical perspective, but also the sociological, which will frame things like capabilities, sense approach, Nussbaum, and so on. I think trying to bring all that together. Another thing is, we often talk about systemic issues, and there's a whole discipline on poverty, and a sociological response to poverty, and actually those thoughts need to be combined, whether it's social minimum from a sort of a philosophical position, minimum core obligation from a legal, or sort of the absolute and relative poverty positions. So I think that those types of gaps need to be pulled together across disciplines, and some of the things that continue to be problematic and emerging are, for example, algorithm, AI decision making, climate justice, and the emerging sort of emergency response to that, and access to justice as a wider sort of discourse and discipline than just about getting to court, which is so important, and those questions are key to enabling access to justice. But it's not just enabling access to the process, but enabling access to a process that results in an outcome that addresses a violation. And I think access to justice literature sometimes overlooks that aspect of it. In terms of the pandemic, again, I think much more reflection is needed for all of us. I think I'm very reluctant, in a sense, to sort of delve in immediately, because I haven't really processed what it means yet. And of course it does need an emergency response. I think, for example, the question around the Joint Committee of Human Rights, it did a response in terms of the human rights implications of COVID and COVID regulations, and economic and social rights. I mean, they were mentioned, but they didn't really feature. And to me, that is the human rights implications. Of course, there's questions around civil and political violations and liberty, and trying to get the balance between right to health and right to people's sort of everyday freedoms. But ultimately, people's jobs have gone. Their access to adequate healthcare is not there. Children can't access education. The economic and social rights violations are exacerbated. They're exacerbating existing inequalities. So the pandemic highlights an already prevalent crisis, and exacerbates it. And I think more people now are aware of that. And so perhaps you will see a change in discourse and a change in priorities. For me, the response of the government, for example, to say we're going to throw money into construction to rebuild society, I don't understand why the response is we're going to throw money into the NHS and the social care sector, which would seem like the obvious place where that response is needed. So I think it needs a change of mindset. And we've got a really important role to ensure that social rights discourse is part of that. And there's a real tendency to shy away because we feel, people might not respond well to, human rights. I'm really reluctant to shy away. I think always you should use social rights to explain, what they mean in the context of those different areas which are impacted. And yes, I think, ultimately it's about legal consciousness in a sense across not only people that are impacted, but the legal sector. I think there's work to be done to bring people along in that sense, because they might not be aware of economic and social rights as legal rights and so on. And in terms of Lisa's question, which is a great one, the critiques, yes, I did present the book at another talk as well. And obviously Koldo's given me a lot to think about in terms of just some of the issues which are not, there's no real answer, but you need to keep, thinking about and trying to address them. Another one was to more clearly set out the pathologies of the deliberative democracy principles. And actually that's something I think that I would like to address further in a subsequent subsequent publication, and about just drawing out that theoretical framework some more. And also a really important critique, which I think again has changed my perspective, was around the speaking in two waves. I sort of set out the first wave of critiques, and then the second wave, I spoke about the pro-hegemonic critique, when social rights adjudication happens in practice, it doesn't work. And actually there are really good responses to that, such as the counter-majoritarian one. But actually there's more critiques than that in the second wave. It wasn't just the pro-hegemonic critique, and there's actually a lot more critiques, like, for example, Moynes, that needs to be addressed as part of the second wave. And so I think that's probably something, again, that I need to think a little bit more about.
Quickly, two questions by Gaurav. I think the first one about the limit of scholarship. I think a danger there is the risk of over-promising and under-delivering. And here the key words, as Katie has used, is the need to have multiple perspectives, multiple theoretical, epistemic perspectives on the matter. By the time a case gets to court, it's already too late by definition, let alone an international court or international committee. I mean, it's already too late. There is nothing they can do really to compensate for anything. So what can we do really to think creatively so the number of cases where social rights are at play diminish, not because there are no legal avenues for them, but rather because policy actors are getting better at preventing issues from emerging in the first place. And I think that requires all the skills. We need lawyers here, we need legal scholars, of course, but it needs also the other approaches. We're putting together at Essex a new module for next year called Economic, Social and Cultural Rights in Context, where we talk about where we plan to talk on economic, social and cultural rights from other approaches that are not the law. We're going to talk about the law, but we're also going to talk about public finance. My colleague Susan Stalabras, who's here with us, she's going to talk about social determinants of health. We're going to talk about international trade. So I think little by little, and there are many examples, I just talk about the one I know best, but little by little, I think we need to get better at preventing problems from emerging and talking about working more across epistemic bridges and talking about the political and policy implications of what we are talking about. And then secondly, what can we learn from the COVID experience? I mean, I guess we have had a very reflective year, haven't we? And we're going to have a very reflective year as well. And we still need time to draw lessons. I think it's too early to conclude that somehow neoliberalism is going to end or anything like this. It could happen, but I suppose we need some more time to reach that conclusion. But there are, I think, a few conclusions that provisionally we can reach. One of them is that many of us have felt vulnerable for the first time. We have felt at risk. Some of us may have lost their job, or may have had loved ones who have lost their jobs, or may have been their life and health may have been at risk, and we have felt vulnerable for some of us for the first time. Many others in society feel vulnerable with no need for pandemic, and the risk they have seen their social rights violated over the years before COVID-19 was a thing. And we expect the state to respond to our needs as society and our individuals' needs. And of course, states should respond and public institutions should respond. But people who were vulnerable before COVID-19 also expected that, and not all of us were listening as much. And that is indeed the second conclusion, is that when things get very dark, we all expect a collective response. We all expect the support of the collective, of the state, of the social. Human rights are, of course, about protecting the individual from the state, from a state interference, and we need to advocate that. But fulfilling human rights, including social rights, also requires the state, also requires public institutions. And we need to acknowledge that, not simply be skeptical of the state. We need that, but we also need to come up with a better state that ensures and fulfills social rights. And the third one is that there is a money tree after all. We were told for many years that there was no money tree. Well, it looks like there is a money tree when there is political will for it. The EU adopted in May last year a commitment for 750 billion euros for the whole of the EU 27, which is a lot of money, very necessary money. Is money that is going to be, some of it as loans, some of it as grants, is money that is going to have to be paid back between 2028 and 2058, which means that my nephew and niece are going to be 60 by the time they end up paying the debts that we are incurring on at the moment. So it is also an opportunity for us to think about what future we are leaving to our kids and our grandkids and our nephews and nieces, because they're going to pay our debts, of debts that maybe we need to incur in, but also we need to think about what sort of other tax options we could explore, so the rich who are alive now don't bequeath a huge debt to the poor kids that are going to be 60 in 2060.
Thanks a lot for those responses. If there are other questions, maybe we can, if you just unmute, you're able to unmute yourself and you could just start talking. This is fairly informal.
I will ask a question. This may not be like very directly connected to the broader topic of reasonableness, because it's still a different field of law, but I was thinking maybe you have your thoughts to share about these recent developments across European courts, courts in Europe, which discuss this informal economy workers, gig economy, so-called gig economy. So we will see after the pandemic that probably unemployment will rise. So many people will shift to informal, more people will shift to informal economy. And it seems that soon the UK Supreme Court will issue its final decision on this Uber case, in which Uber drivers were recognized as employed, their employment status were recognized in the lower courts. So what is your thoughts about these developments? So as with this complex multi-approach, there are things that we cannot really resolve immediately, but is this a field of law that we could also focus in, even within traditional approaches? That the proportion of informal workers will only rise, so it is topical enough to shift some paradigms about this.
Yeah, I'm happy to come in there. Mariam, thank you so much. It's an excellent question, and it actually really highlights a couple of the other issues that I would point to in terms of emerging scholarship. I mean, one of them being like sort of complex remedial responses to complex issues and systemic issues, and the second being privatisation and sort of economic and social rights in the private sphere, and the real difficulty around pinpointing who obligation bearers are in that context. And I absolutely agree with you that this is completely connected, and it is an economic and social rights issue, and the precarity of work and the dissemination of workers' rights is of huge concern in the UK, especially because the sort of minimal criteria that were part of the European Union framework are now no longer necessarily going to stay in place. It's open to erosion over time and so on. And actually, when you were speaking there about those types of cases, and it will be interesting to see how different countries respond to this, but it reminded me of the recent case in South Africa looking at domestic workers. And actually that's a fantastic judgment to read. And like I think I will always say that it's never a perfect response. There is no panacea. No one's doing it perfectly. But judges who are alive to the wider context, and in that particular judgment, I can't actually remember the name of it off the top of my head, but it's about domestic workers such as cleaners not being covered in terms of employment rights. And the court speaks about substantive justice and substantive equality, and really makes quite an important leap in that respect about looking at historical injustice and historical inequality emerging and as a legacy of apartheid, and bridging that gap, which is to essentially apply economic and social rights horizontally. And ultimately, I mean, there's great work that's been written about how you regulate the private sphere. And it is the state's responsibility to regulate in such a way as to ensure the provision of economic social rights occurs in compliance with the international human rights law, which includes things like minimum wage and employment rights. And so regulation is really the responsibility of Parliament and government, but ultimately, if they fail, ideally, yes, courts should be stepping in to make that horizontal application, such as in the case of the domestic workers in South Africa. And in that judgment, they had used really key evidence from the likes of Professor Montefiore, who's based at UCL. So it was quite an innovative an important judgment, and a lot can be learned from that approach. I'm sure you're aware of it yourself. So yeah, I'm following. I mean, one of the big things that's emerging is, for and a continuous problem is the privatisation of public services as well, and it covers much of the same ground about regulation in the private sphere. And yes, state obligations should cover that, and ultimately, ideally, courts should be able to step in if they don't.
Thank you.
Do you have something to say about that, or?
No, it's all right. Thank you.
Okay. We are, unless anybody has any other questions, we're almost at the end of time. Yes. So thank you once again to Katie and to Koldo for this lovely session. And we sent a form in the sign up in the chat, and you can sign up and receive updates about us. We're also looking to set up a reading group for early career scholars and doctoral students. So it would be lovely to have you be a part of it. So thank you once again to Koldo and to Katie. Thanks a lot. And we hope to see you again soon.
Well, thank you so much.
Thank you. Thanks, Gaurav.
Bye.
Thanks, Katie. Take care.
Yeah, thank you. It was lovely to get a chance to speak to you all. So thank you for organising it, and hopefully see you all again soon.
Yes, thanks.
Hopefully.
Bye.
And Mariam put the case in the chat, actually, the South African case, Malanga and another V Minister of Labour. Thank you.
Thanks a lot. Bye-bye.
Bye. Bye-bye.